The title of the presentation is How to Get Paid and Understanding Your Rights and Duties under the Illinois Mechanics Lien Act. I'd like to thank everybody that's in the room tonight too, that's here with me to give me a little bit of crowd feedback as we go through the presentation. By way of introduction, I am bar certified in Illinois. I'm going to use this chart just to give you some familiarity with who I am and what I've done in the past. I did notice from this flip too that I neglected to say that I was a Chief Procurement Officer for the City of Chicago, which is a very important point to place in the flip tonight, because it also goes to my experience in the construction world and dealing with both primes and subcontractors and some of the problems and pitfalls that they find in getting paid in the Chicago area marketplace. Now, let's talk about, just quickly, what this presentation is. This really is a guidepost presentation. I'm going to guide you through a process called the Mechanics Lien Act. Now, notice I didn't say that I'm going to whip out a magic wand to magically pay contractors monies that they're due. This is not meant to provide, this presentation is not meant to provide any sort of legal opinion or legal advice. It is simply a guide that will help contractors determine how to use the act to their best benefit. Now, with that said, I wanted to briefly give, this is a very high level view of what the Mechanics Act is. It's found under 770 ILCS section 60, and it breaks down into two components. One, and we're going to talk about this first, are mechanics liens on private projects. And then the second half of the presentation is going to focus on mechanics liens on public funds, which the law treats differently based on where the funding source comes from. Now, we're going to first, again, as I just mentioned, look at mechanics liens on private projects. I'm going to give an overview of what the Mechanics Lien Act is. We're going to talk about some of the elements of a sworn statement, lien waivers with payment, and we'll get an understanding of what types of lien waivers are used in this process. We'll understand how to perfect and prosecute lien claims, and what information needs to be provided on a lien notice, a foreclosure suit information, and then there may be some contractors out there that are doing work on single-family homes, and we're going to briefly discuss the duties and responsibilities of those contractors. Now let's jump into the Mechanics Lien Act. As it relates to private jobs, we're going to be looking at Section 5 of the statute. That section requires that every owner obtain a sworn statement from its contractor. And that also means that every contractor is required to provide sworn statements to the owner, regardless if the owner asks for those sworn statements or not. An important point here is that the sworn statement must show the names, addresses of all parties furnishing materials and labor on the project. You can't come back later on and try to add those names, because your suit will be void if those individuals are not located on the actual claim itself. The sworn statement must also show the amounts due and to become due to each supplier. Now, I did not bring a copy of a sworn statement, even though I can't provide one at a later date. For those of you who may not have seen a sworn statement, it includes a number of different columns. Those columns might amount to the initial contract and materials on order, the amount that's previously been paid, the amount that is to become due, and it also includes the values that will change over a period of time based on the changes that occur to that contract. And when I mean changes, it could be change orders that affect the value of that contract. And then, of course, and I'll reiterate this again and again throughout the presentation, the sworn statement balances must balance. Now, I talked a little bit about what's the elements of a sworn statement. As I mentioned, the sworn statement must balance, and it must include all the work of the project. You cannot leave out any particular work. You must include all the change orders or changes that have come about through the project. That must be documented. Let me pause briefly by saying this. This is an exercise not only of how to get your money, but it should be an exercise too of what records should be maintained and maintained meticulously. Uh, the one thing that I don't want you to do is try to put the fire out when the house is almost burned down. What we want to try to do is to do some preventive medicine. So at the beginning of your construction projects, please keep meticulous notes. Your record should include all the details that would possibly be used in a lawsuit at the end of a project. I'm not wishing that upon you, but I want you to be prepared in the event of suit. Again, the disputed items should also be included on those sworn statements. And I have no payment will be provided for those items that are to be let trades. For those of you who may not know what that means, is that early in the project, you may have trades that have not been contracted for because you're waiting to see if you can get a better price as the project moves forward. Those items should be included on your sworn statement. However, work will not be paid for until the work has been contracted and performed. And typically on private contracts, it's going to be necessary for you to include an architectural certificate, which should support the work progress and the work that has been done as of that date. Let's talk a little bit about lien waivers with payment. There are two different types of lien waivers that I wanted to make sure that we are on the same page with. Trailing and current lien waivers. Trailing waivers you'll find predominantly, matter of fact, not even predominantly, you'll always find those on government projects. A trailing waiver means exactly what it says. Let's take a look at a pay app. You know, the first pay app will not have waivers, of course, because you don't have waivers that you've given to show that work has been paid for. You will see waivers on the second pay app, and what that waiver is, it's submitted by the subcontractors to the prime, indicating that they have been paid for work that was on the first pay app. I want to make sure that our subcontractors out there that are listening to the presentation understand that when they provide that pay app, that waiver, that's indicating that they have been paid on the job, paid for the work that has been provided, or the labor, or the materials, etc. That waiver states was done. You can't now later come back and say that I never got paid for that work. That's like an affidavit. You're saying that you were paid. The current lien waiver is found on private jobs, on those private jobs, and that's saying basically the vendor's giving you a waiver on a condition. It's conditionally saying that if this check clears, then the waiver is good. It's a way to protect a subcontractor in the event that they receive a bad check from a prime, and that does happen. Trade contractor waivers, the waivers should also identify and include the material suppliers. Checks tendered for current waivers. I just mentioned that the check has to clear in order for the waiver to be effective. As I've mentioned before, and I'm going to be a broken record, these waivers must also balance with the sworn statement. In certain jobs, and I have had experience in this on the city side, one of the things that you saw from my background, I was the former executive director for the Public Building Commission of Chicago. And on certain projects where we felt that the prime contractor may be on wobbly legs financially, the owner, I issued joint checks to ensure that the subcontractors were actually paid for work performed. That joint check is a way to protect the interests both of the owner as well as the subcontractors performing work on the project. Now, perfecting and prosecuting lien claims. We're getting into the part of the presentation where I want to point out that we've got to keep track of our calendar and those key things that are indicated on a calendar because they have deadlines associated with the Mechanics Lien Act. And this is, you're going to find too when we talk about the public funds that there's different timelines associated with the Mechanics Lien Act as it relates to both the private and public jobs. In this instance, you should have somebody in your shop that is maintaining a calendar and tracking these dates, because if you miss any of these dates, you've missed your opportunity to claim monies under this act. Time runs at substantial completion of the work site. Now, I want to stop for a second here to explain what I mean by substantial completion of work performed. You may be a subcontractor on the job, and I'll use this as an example. You may be the excavator, and your work is done primarily early in the project, and you're completed earlier in the project. If you have not been paid, the timeline is associated with your substantial completion of your work. It is not the substantial completion of the entire project. If you allow the project to continue to its substantial completion, you've missed your opportunity to file suit. So with that said, that is one of the baseline dates, the substantial completion of your work. Again, this is a documented process that both the architect will provide its certificate to indicate that your work has been completed at a certain time and start the clock to move. A notice of claim to the owner and to the lender must be done within 90 days of substantial completion. Now, I want to stop here because we're hitting on another key word called the owner and the lender. It's going to be important, and I want to preface this by saying this. I do not anticipate you as a subcontractor to be doing some of these particular duties. You're going to hire somebody like me who goes out and tracks these dates, who identifies who the owner and the lender are in a particular construction job. In this instance, I wanted to point out, though, just so that you're dangerous in this process, that the owner, in order to determine who that owner is, your attorney or someone in your staff should be doing some legwork to determine who legally is the owner of a particular piece of property. That would mean that you would probably have to run through assessor records, any kind of tax-related records. You may even have to look at banking information as it relates to the lender. I say that because in some instances, a lender may sell or assign its duties to another bank, or the bank may be purchased by someone else. You have a duty to determine who in that chain of custody has some association with that property. Again, I look at the 90-day timeline from substantial completion. You've got to get a notice to the owner and the lenders. And then you have 4 calendar months to file notice of your lien. Notice I did not say 120 days. It is 4 calendar months. If you use the 120 days, you again have missed your responsibility under the Act, and you will be unable to file a lien against this private job. And then from that point, you have 2 years to file a foreclosure lien in court. Now, that's not, I want to make sure that we understand what that 2 years is from. That is, again, from substantial completion of your work. Not completion of the project, not substantial completion of the overall project, but of your work. Lien notice information. This is what must be on your notice, and it would not hurt if prior to needing this notice that you completed in your shops. You might be able to find a guide for a lien notice online. I'm sure as an attorney, I'll talk with my group here in house to see if we can put one online so that you can see an example of one, and therefore you could use it in a cookie cutter kind of fashion depending upon your need. But you must have the street address of the project. I want to point out you should get a formal verification of what that street address is. Oftentimes, we may think an address is one thing, but the government may have it at a different address. In order to get the correct address, again, I would look for the assessor, the tax record. I look for some sort of record from the recorder of deeds to see what that exact address is. It is that particular, and you don't want to lose out on being able to file suit because of some technical mistake that you've made in the filing of your notice. You must include what we typically refer to as the PIN, or the real estate tax permanent index number, along with the legal description that matches up to that PIN. The date of the general contract. Now, it's possible, I want to stop just briefly on this point. You may be a subcontractor that has contracted directly with the owner. In that instance, you would be viewed as a general contractor. You'd have to put down the date of your contract on that notice. If you are not the general contractor and have an agreement through a prime, you'd have to put down, as well as the general contract date, your subcontract date. Let me stop again. I don't want anybody doing work on any kind of public or private project without a contract. I've seen that occur on a handshake basis, and in the end, you're greatly disappointed when it comes to your payment or to the amount of money that you should have been paid on that contract. So please ensure that you have a contract to perform the work.
Question.
Yes.
Can I ask a question?
Yes, we have a question from the floor.
Okay, so regarding the contract, I have seen where individuals or companies have sent in a proposal / contract. And that's basically what they're proposing, and then they are assuming that if they get the work and they sign off on that, that proposal becomes a contract.
Yes, yes.
Is that indeed a valid contract, or is it just a formal proposal?
That is an excellent question. And timing is everything. If you send in a proposal and it is signed off prior to you performing the work, that becomes a contract.
Okay.
If you perform the work and you're waiting for the proposal to be signed and sent back to you, that is not necessarily a contract. You have just performed work without having a contract in place.
Got it.
So, you run the risk of people doing strange things with a piece of paper once the work has been completed.
Exactly.
So the recommendation that I would give in that particular instance is don't do any work until you've got a piece of paper signed that says perform this work.
Got it. Okay, thank you.
I believe, okay, the last work performed, again, that's the date of substantial completion. That does not include, you cannot count punch list items. That's substantial completion of the work, okay? Amount claimed as the lien. So you should know from the value of the work that was to be provided to what you were paid out, the subtraction of that should account for the claim amount. And then an affidavit to support the claimant. So an affidavit is strictly saying, I so-and-so attest that I did particular work on a particular project and I'm owed this amount of money, and that the sworn statement that I provided indicates the amount of money that I am to be paid. And you're basically getting that notarized, and that's your sworn statement that I'm owed this money.
Okay.
Okay, the foreclosure suit information. A lot of the information that you provided on the notice will also be used for your suit information. So I'm going to cheat a little bit because I want to make sure I get all my notes in here. This really answers the question of what if I don't get paid after I basically threaten them with my lien notice, and these devils still haven't paid me my money. What can I do to get paid? Well, you've got to file suit. And we talked about that 2-year period in which you have from substantial completion to file your suit. In your suit, you've got to provide the recorded lien document number, because after you have this notice sent, you've got to record it. And I told you that you had 90 days to record that. So you've got to list that in your suit. The date the lien notice was recorded, as I just mentioned. Minutes of foreclosure. What that is, you get that from a title company, and it shows, it identifies the parties claiming interest to the land, as well as identifying any other supporting documents that would show anyone else that may have a claim against this land.
You
Because
said the assessor's office? Where do you get this?
you're going to get that through the recorder of deeds.
Oh, recorder of deeds. Okay.
Because everybody has a duty to record their interest or their claim on a particular project.
Got it.
And that the recorder of deeds is a holder of that record.
Okay.
Okay. You also have to include in your foreclosure suit successors to the documented parties. And what do I mean by that? It's possible that the original owner has died and they've left this property to their next of kin or their assignees or to their litigants. And you've got to make sure that they're included because they have interest now in this property. So they must be included in your suit. As I mentioned, the heirs and legatees. And it's possible that a corporation has purchased this land. So you need to check the records to see if a corporation has purchased that property and if they've been merged with another business. All parties, all interested parties must be included in the suit. The failure to include any particular interested party could void your suit. That's why
the recorder of deeds will give you all of this information.
The recorder of deeds and I'm trying to think of some other sources in which you will get that information. On the lender side, because remember the lenders are involved in this as well, you would have to check existing bank records. So let's say that the bank sold its mortgage on this property. You'd have to check their records to see who they sold it to, and it's possible they maybe it was sold again. But you have to exercise that due diligence to make sure that the lender or the interested party that has mortgaged this property is also notified.
Okay.
Okay. Now, I mentioned earlier that we may have some subcontractors that are performing work on single family owner occupied properties. And they have a special duty and responsibility to provide an owner with information. I typically like to stay away from these things because admittedly, this pool of contractors typically doesn't comply with the law that's out there. And what I mean by that is they must provide the owner with a sworn statement. And that sworn statement has got to provide them, prior to doing any work, has got to provide them with all the names, duties, and responsibilities of every subcontractor that will be working on the project. That is, they owe that responsibility to the owner. If they fail to provide that information, the contract could be voided. So you could fool around and do all this work and not get paid because you didn't comply with the statute. In addition,
and I bet most contractors just don't realize that. I don't think they skirted to be, you know what I'm saying? I really don't think a lot of contractors even realize that they're supposed to do that.
Ignorance of the law is no excuse.
None?
Ignorance of the law is no excuse. Okay. So there's a responsibility of every contractor to follow the existing law that is there. As a matter of fact, one of the simple things that a lot of contractors don't use, and this is by order of the Attorney General's office, is the Attorney General's brochure. And that brochure lays out what exactly should be in the contract in order to protect the owner of the property. That's a duty that the contractor owes the owner. And it's a brochure that you can get it off online, and you do, and the contract, the law requires that when you give that brochure to the owner of the property, they have to sign a receipt saying, I received this brochure. The simple failure of getting that receipt signed, again, could void the contract.
Okay, that's good to know.
Yes, yes. Now, subcontractors that are working under this GC, that small GC that's doing this home work, they have a responsibility within 60 days of performing, before they perform the work, of notifying the owner that I am a subcontractor on this job and I am about to perform my work. That's for the protection of the owner of the property. later on, you don't want the owner having to face a number of subcontractors who come up and say, wait a minute, I was on that project too, and the owner had no idea. He's under the impression I'm paying this contractor to provide me with these services, and all of a sudden somebody comes out of the blue. So again, the absence of fulfilling these compliance-related issues on this statute could void out the entire contract. And I've seen people, I've seen vendors that have are trying to enforce what they believe is their right for payment, and they have not fulfilled these functions.
I have a question.
Yes, yes.
All of that information in that brochure is at the Attorney General's office.
You can go online, you know, the magic of technology. You know, you can go online and pull these brochures down, print them off. Yes, and the receipt, you can find a receipt and Google the receipt and have those folks sign up and put it in your records. Give them a copy of the receipt as well, right? There's nothing called an overabundance of documentation, because in the end you may need that.
And if you have PIN numbers, you can go online to the assessor's office and find out if liens have been placed on properties.
Yes.
Find out how many people there are on the lien, all of that.
Yes, yes, this is all true. And matter of fact, you can also go on to the Recorder of Deeds website, and if folks have recorded their lien, that'll be on the recorder site as well. Okay. All right. So what I've done now, that we're about to conclude the private projects, and we're going to move now to the public funded projects. I brought this flip, or at least inserted this flip into the presentation to show you that we're going to be talking about some of the same things on the public funded projects as we talked about on the private projects. However, the law treats some of these elements differently, especially as it relates to some of the timelines associated with being able to file a mechanics lien. All right. Now, I'm sure from the sworn statement, I think I'm okay. I'm a little out of whack, but we'll get it together. Sworn statement essentials. Some of the same things that you saw on the private side, you see on the public funded side. The sworn statements must always balance. I don't care what you're looking at, what side of the fence you're looking at, private, public. These statements must balance. If you're not good with math, get a spreadsheet. Use a spreadsheet. You don't want to mess up and have your numbers off, because when you have your numbers off, at least from my standpoint as an old administrator, if I see one number off, I think the whole report's wrong, right? So your credibility rests on how you can add.
Okay.
All work must be included on the statement. Again, you can't later on add work that wasn't on the initial statements. And we realize that the statement may change to some degree based on change orders, but it's got to balance at the end. Okay? Scope changes must be documented. As I mentioned before, this is to protect not only you, but the owner as well. I can't tell you the number of people that after the fact, vendors coming back saying, wait a minute, they told me that I needed to do this work. They said it was a change order. They said, just keep going and I'll give you the approval for this. Do not perform work without a signed off approved change order. I know it's easier said than done because you're trying to please your client, etc. But in the end, you're the one that could be burned up without that approval.
90% of the time, when there is a payment issue, it comes from that scenario.
Yes, yes.
There's been a change order in the work. You've been asked to keep moving and keep it moving. You're pleasing everybody. And then at the end of the day, there's a discrepancy on what was agreed to when you made that arrangement.
Now, one of the reasons why the law says to include this disputed change orders or changes is that offers you some protection later on in the litigation process, because now you actually have a physical document that you can refer back to and say, I submitted this on my sworn statement. They knew about this change and they didn't do anything about it then. So how are they arguing about it now? Okay.
Okay.
And again, the architect certificate should be provided so that it shows the progress of work that has taken place. Okay, now I'm back on track. Notice before, when we were talking about private funds, we were actually leaning property. Here, you cannot lien the government's property. However, what you're leaning are the funds that are associated with that property, and it's the unexpended funds that are associated with the project. So if you're owed more than the funds that are available, you're going to get a prorated share of those funds that are available, because there may be some other subcontractors in the mix that are also vying for these dollars. So, well, Montel, how do I get all the money that's owed to me? Well, you're going to have to bring in your action for foreclosure, an action for a breach of contract, and if they have spent funds that were actually, if the prime contractor has actually been given funds by the government entity and they've spent those funds and that was your money, there's another action that you can bring for their breach of their fiduciary duty, their duty to pay you the money that you were owed. But those are separate actions outside of the mechanics lien. Okay, those are separate counts. Oh, and by the way, there is no lien protection on federal jobs. That's one of the things that offers a subcontractor or a contractor some protection is a surety bond on those types of jobs.
Okay.
But that's another presentation, and I won't dive too deep into that. Okay. Liens with payment. Now, I've already gone through to talk about what trailing versus current lien waivers are. You now know that on public jobs, we're talking about trailing waivers. And on the trade contractor waivers identified include all material suppliers. Those are your cousins in this process. You got to include everybody that's due money on this job. And that includes, in some instances, it may include someone that's provided a certain service for you outside of a supplier that's unique to the job, but they should be listed as well. Waivers must balance to the sworn statement. And as I mentioned before about that example, when I had a troubled contractor, prime contractor, and we did a joint check to ensure that I'm protected and that the sub gets paid, you'll see that a lot on public jobs. How do we perfect our lien? Now, remember before we talked about the 90 days and the 4-month calendar months, and the 2 years. In this instance, the lien is valid as long as appropriated funds are available. The minute you file your lien, it's the government's responsibility, and you got to file it on the right person, the right government official. Those funds are frozen, and nobody can touch those funds until there's been some determination as to who's owed money. Okay. Forgive me, I know I'm not facing the camera as much as I should, but I'll correct that. Lien perfected with service of notice on the appropriate official. I want to stop there for a second, because sometimes if you're the subcontractor, you may not know who the appropriate official is, but there's a way to determine that, and you can determine that by filing what's called a Freedom of Information Act request, and where you specifically ask, I'm working on this job. I'm not using this for any kind of purposes outside of making sure that I have the correct information. I need to know who is the owner of this particular project. Let me give you an example. I mentioned before that I used to be the executive director of the Public Building Commission. Some of the subcontractors on that project while I was working for the agency, they may have been working on a school or a park that's owned by the park district or a school that's owned by CPS. And you as a contractor may believe because I'm working on a school, the official on this has got to be somebody from CPS. Well, no, that's not the case. In that case, it was the Public Building Commission who was the owner because they've been given funds by the CPS. They now own those funds and they now build a school. So your failure to provide notice to the appropriate city official could also void your claim. So it's important that you understand and determine who the actual owner is when you file your foreclosure claim. Okay, your foreclosure action must be filed within 90 days of your notice on the appropriate official. So you've got to file your claim within 90 days. So notice, out of the grand scheme of things, the key date for a public project is at 90 days from filing your notice on the appropriate official, as opposed to on the private side where you've got the 90 days, the 4 calendar months, and the 2 years. Okay, and then after that 2 years, you're barred. In this instance, you're not barred from filing your claim until the funds are gone or expended. Just as before, your lien notice, the thing that you're giving to that appropriate public official must include certain information. It's got to be sent or given to the proper public official. It's got to give the correct identification of the public contract. So how do you find that out? These days, a lot of the governments are getting kind of sophisticated with placing their information online. So a case in point, the city of Chicago has a vendor database in which you can plug in the name of the contractor and it will show you all the existing contracts. It should also show you that you're a subcontractor on a certain contract, and therefore you can pretty much isolate which contract you're talking about. If in doubt, then you should do another Freedom of Information request to ensure that you're focusing in on the right contract. You've got to include the date and scope of the subcontract, and that should be easy because you've got a subcontract. That's your contract. So you should be able to look on your contract to see what duties you were given to perform on the contract, as well as the date of that contract. By the way, you should also include the date of the prime's contract in this notice as well. You want to do everything you possibly can to identify exactly what contract you're looking for. And then you're going to give what the total value of your work and the total payments that you received, and that should equal what your claim amount is for this particular job. Now you got to file suit, right? Within 90 days of giving that notice, you got to file suit. And your suit information should contain the date the lien notice was served, forgive me, because I should have said to who you serve notice on. You should also put that in on your suit information. Other notices on the project. This is that due diligence thing I talked about before. You got to see if there's been other claims filed on this particular, because what the judge would like to do is to merge all of those claims so that this thing can be heard all at one time. So he's relying on you as a claimant to include all the other claimants that may be part of this particular suit. And then you got to tell the court how much in funding should be still on this contract that assures me I'm going to get paid. Because again, if there's no money left, then you're out of luck. But if there is money left, then you're in luck. Okay. Now, how do I determine if there's money left? Well, you may have to, again, FOIA the government to determine what was your funding source. Let me give you an example. It's possible that you're working on a project that shares funding resources. There may be separate funding strips, as I've got here on the chart, where it shows me money came from this entity and it came from this entity. Now, you're in good shape unless one of those entities is a federal funding strip, because remember, The only thing you have then is a surety bond that you can rely upon. But if you're talking about state entity or city entity, you just have to name those funding strips and ensure that there are funds available in those funding strips to get the money that you're due.
So if there are other people that have the suits in, how do they prioritize?
It's a pro rata kind of thing. It's okay. I was paid this amount of my contract, and that was 60% of the value of my contract. And it's a heck of a math exercise that the court actually will go through to determine, okay, you're based on this amount of money left, you've been paid this, there's only so much, so you're going to get this percentage, and then the next group gets this percentage. Somebody, in the case where there's not enough money to pay out all the subs, everybody's going to be crying. It's a shared pain, unless again they can come back on that breach of contract kind of issue to recover outside of the lien area. Okay, so it's I commend the court for being able to go through that exercise. So, and I mentioned before, it's a breach of contract, and then there's another action that can be brought called a breach of trust. So the breach of trust goes to that issue where the prime has been paid and they've spent your money. Because if you think about it, when the prime is paid on a public job, that's not their money, that's the subcontractor's money, and the prime is holding it in trust. And they should be paying out based on who's on their sworn statements and who's owed money for that particular period, based on the work they performed. Okay. Now, that concludes the presentation. This is just a summary sheet. Well, I wanted to show, as you see the things that are in bold, that's kind of the overlap of what you would see on both sides of this act. But we know, just based on my presentation, that things are treated differently from the public versus the private. Predominantly, you've got to be keyed in on the dates on the private side. And if you miss any of those dates, your claim would be void. The key date on the public side is that 90-day notice from the time that you've noticed the appropriate public official. Now, what do I want you to walk away with from this presentation? You can get paid, but the burden is going to be on the subcontractor to keep the records that are necessary to support the claim. Some things you can prepare for on day one of the contract, getting the address of the location, the property description, the pins and all that stuff, that can be done on the front end. On the back end of that process, you're going to have to do some due diligence to find out, well, has this property, at least if we're talking about the private side, has the property been sold, has the owner died, et cetera, et cetera. But a lot of the legwork can be done early in this process. I challenge you to make sure that you keep those kind of records to keep this thing in order.
And is that PIN number something that's readily available?
Yes.
Property?
Please forgive me, because I'm so used to going to the resource to finding what I need.
Right.
You can go through a couple of different resources to get that done. You can go through the assessor's office. Matter of fact, I want to say that the assessor's office has a nice little tool. You can plug in what you believe is the address, and it can lead you to the PIN. And then if you got the PIN, now you can go to the recorder's office and get the legal description. So, there's not like a one-stop shop, but you can get that information online without having to go out of your house to get it.
Okay.
Okay.
That's great.
I also want everyone to understand the timelines. If you miss a timeline, it could be disastrous to a possible claim. If you've got somebody in-house that tracks all this stuff, or challenge them at the beginning of the project to say, look, I need you to keep track of my records. And as this process goes along, and if we need to file notice and a claim, I need you to track those dates and track them meticulously. With that.